working and planning with individuals and families with special needs and disabilities. He's worked with over 120 organizations nationwide that cover approximately 60 various types of disabilities, disorders, and diseases. He speaks at conferences and organizations annually, works with families throughout the country to help them plan for a better future, and we are excited to have him here today.
Thank you. Let's see, it's working perfect. Thank you. Test, test. Okay, excellent. All right, thank you all for coming to attend the session. Hopefully it will be worth your while. My name is Andre Sam, and I'm with the Disability and Special Needs Project. We're a planning services firm that provides families with comprehensive planning as it relates to individuals who have disabilities and special needs. And it's going to be a lot of information I'm going to be throwing at you. Karen is running around here with info guides and feedback forms for you. So if you want, you are welcome to take notes on the back couple of pages, or if you have your own system, by all means, I would recommend doing that, because a lot of the information in those guides is more high level. It's not going to go into the specifics that I'm going to go over verbally or that are on the slides. And then there is a feedback form. If you can tell me, if you can fill that out at the end, tell me what you like, dislike, want to see changed. That's how I get better. And again, we have hour 10, hour 15 to do this. I could spend an hour talking about guardianship alone, let alone all this other stuff. So everyone has their own unique circumstances. I am happy to schedule a complimentary private meeting with you at a later date and time to go over this information, but as it relates to your circumstances. Totally optional, totally up to you. You just check that box on that feedback form and we get that taken care of. Just a little quick thing about me. So how I got into this is I don't have any individuals in my family with intellectual or physical disability. Well, actually I do now, but that's another thing. So I was on the baseball team in high school, and grades were not enough. We had to do volunteer work. I'm 14, 15 years old. I don't know any volunteer organizations or whatever, but someone on our team had an in with the Special Olympics. So that was kind of my in to fulfill that requirement. But I enjoyed it. And then I did some tutoring classes with individuals who are on the spectrum, and I continued that into college, but I graduated with a degree in economics. And I kind of wanted to go into the financial advising, but for the special needs community. So I kind of was taking what I could see families dealing with in, behind their closed doors, as well as information learned in the classroom, kind of combining it together for comprehensive special needs planning. So I've been doing that for about 12 years now, working with organizations, families all across the country, covering anything from Moat Wilson to autism, Down syndrome, muscular dystrophy, hydrocephalus, spina bifida, you name it, probably covered it, okay? So, disability and special needs planning, a lot of people have heard of planning, but they don't know what exactly it entails. And so, when it comes to planning, well, we are going to be going over the key aspects of it, which are the legal planning, government benefits, the budget and financial planning, and the lifestyle transition planning. Those are the things that need to be focused on to ensure that your loved one is going to continue growing and developing and maximizing their opportunities now, as well as in the future. And I would say that 99% of people would say that, well, planning is important. And yet, so many fail to plan. Why is that? If everyone says it's important, why are so few actually doing it? Well, oftentimes, you're just trying to make it through the day. You're trying to make it through the week. You have things that are more pressing that you have to immediately address. These are not the most comfortable topics to discuss. There is a mortality aspect to what we're discussing. Financial issues or so, there can be that. Don't know who and where to turn to for resources. And oftentimes, we as human beings are impatient. We want the immediate results. So whatever we're doing, even if it's the tiniest bit of improvement for our loved one, we want to focus on that. And when it comes to this planning, it can be difficult because it doesn't feel tangible. It's not real. It's almost a fugazi. It's just out there. You don't know what the future is going to hold, okay? But I very much assure you that the more planning that you do ahead of time, you're going to maximize your loved one's opportunities for growth and development, being able to participate in various things. So, some things to think about. What exactly are your expectations for your loved one? You know, if while you're around, upon your passing, what do you want them to continue pursuing? You know, whether it's school, work, living situation, activities, Medicaid and SSI. Those are government benefit programs that we'll be going over. Are you planning on relying on those? How much are you planning on relying on them? If you rely solely on them, are you aware of the quality of the care that you'll get? Quality of the services, the quantity of services, or the wait lists that are involved with Medicaid-funded group homes. You kind of get what you pay for, so if you're not paying much, probably not going to get much. If something did happen to you, what does life look like for your loved one tomorrow? Who's going to take care of them? Will that person or those people know what to do? Is guardianship needed in the future? People hear a lot about guardianship in various ways. We'll get a couple of those things clarified today. How are you going to set aside funds for your loved one's benefit when Social Security and Medicaid put limits on their income and assets? So, we will be going over how to deal with that. And just real quick disclosure, this content is for informational purposes only, not to be construed as financial or legal advice. Taking personal notes is recommended. And as we go through each of these aspects, I will have sometimes where I'll open it up for Q&A. Just keep in mind that if it's very specific, I might have to tell you, look, happy to provide a complimentary meeting. We can talk more about it to get more details. But we'll do a little Q&A back and forth as we go through this. So like I said, the 4 key aspects, the legal planning, government benefits, budget financial planning, and the lifestyle and transition planning. We're probably going to spend majority of our time on the legal planning and the government benefits, but that doesn't mean the other 2 are not important. So legal planning, just to gauge my audience here, just by the raise of hands, how many of you are here for a loved one who is 18 or under, or 17 and under, I guess? Okay, just about everyone. Raise of hands, how many of you are between 14 and 17? Okay, a lot of first-time families, newer families, okay. All right, so, and by the raise of hands, how many of you have set up any sort of legal plans, like setting up a will, setting up a trust? And those who have their hands raised, how many of you have a special needs trust? Couple people. Do you know what type of special needs trust you have? That's a great start, and that's more than most people offer, so kudos to you. We'll go over the specifics here about the different types and the pros and cons with them. So for those of you who didn't raise your hands that have any plans in place, fear not. I have good news for you. The state you live in has a plan for you, okay? Why are you laughing? Who's laughing over? It's not good. I just said it was good news. I do have some bad news for you as well, and that is your state has a plan for you, okay? If you don't have a plan in place, the state will decide how your assets are to be distributed, who they are to go to, and the state will decide who to appoint as the successor guardians over any minor children or adult incapacitated children, okay? So it's probably a good idea for us to put a couple of documents in place, and each one has its own purpose. So we'll go over the last will and testament, family trust, special needs trust, and guardianship and alternatives. So the very first important document to have is a last will and testament, otherwise known as a will. This is an individual document that gives you the ability to state who is to receive what. You have things. Where do you want them to go? And this is where you would list who is to serve as a successor guardian. Now, I can't speak for everyone. In our documents, we also list anyone who needs to be excluded from serving in that role. A couple laughs over here. If you don't know what I'm talking about, congratulations, your family's perfect, and there's no problems. However, for some of us, we have a bad apple in our family tree, someone who might look at your loved one as a paycheck. Might be a good idea to exclude them from serving in that role. So you can exclude just about anyone except a biological parent. Usually I get someone that says, crap, didn't get that though. But yeah, you can't exclude the biological parent. Now, a will is better than having nothing, okay? And a will is something that if you want to go the DIY route, just for transparency purposes here, you can. You can go the do-it-yourself route. If you went on the internet, did a little bit of research, found a template, you could. It is easy enough. Now, if you don't want to and you're in the position, then yeah, you can retain legal services to do that for you. But just know it is easy to do. And with it, like I said, you can list whoever is to serve, who's not to serve, and those are all great. But if you only have a will, then any asset that you have that doesn't have a beneficiary will go through probate. By the raise of hands, how many of you have ever dealt with probate? No. Yes. How fun was it?
Well, I work in the mortgage industry, so we deal with it with titles.
With titles and selling the properties. It's a mess, and you don't even deal with the whole thing. You just get the fallout from selling a piece of property. So, for those of you who don't know what probate is a division of the court system. And their job is to reassign assets to go to who they're supposed to, as stated in the will. Okay? Now, the government doesn't really do that for free, so there's usually filing fees, and oftentimes, due to the complexity of the case, there will be a percentage fee assessed to those assets, where they will take a percentage, 3 to 10, 3 to 15%, somewhere around there, for simply doing that job. Okay? And it can take a while, because a lot of people fail to plan, so it's a little bit of a bottleneck, where the court system is clogged for 8 to 12 months oftentimes. So if anyone needs those assets right away, yeah, they're going to have to wait until probate closes that case. Okay? So a will is a public document going through probate. So technically, anyone could go online and they could see what that person had and where those things are going. And part of probate is you have to notify any debtors, creditors, Medicaid, so that anyone can come through and put a claim on those assets. So if there was anything owed, then yeah, you have to go through that process. So that's a big problem. And the other problem is you can't list your loved one by name who needs to either be eligible for their government benefits now or in the future, or if they already have them, can't list them as a beneficiary. Because if you do, it will get them kicked off their benefits, because they can only have $2,000 of assets in their name. And yes, Medicaid has, from time to time, when they go through these wills, they run the names of the beneficiaries, and that can affect it. Okay? So we have a couple problems there, and we're going to solve a couple of them with the second important document to have in place, and that is the revocable family trust. If you know it as a living trust, same thing. Okay, family trust, revocable trust, semantics, okay? A family trust is a legal document separate from your will. And you can state who is to serve as the trustees or successor trustees managing those assets upon your passing, who is to receive those assets, and you can put whatever conditions you want. So you actually have a lot more control from the grave, if you will. So if you want assets to go to a certain child and you want them to have it split, 50% at 21, 50% at 30 years old, you could do that. You can do whatever you want with it. And what you do is you retitle your assets to go into the trust. So things like a house. You would have a quitclaim deed where you're deeding your house to your trust. You still have total control over it, okay? You're not giving up control. But the whole point of doing this is to avoid probate. Anything in the family trust avoids probate. think of the family trust almost like TSA pre-check at the airport. You kind of just zip on through, you don't have to take the shoes off, the laptop out. Whereas probate and just having a will or having nothing at all is going through the long line, taking the shoes off, except that at the very end of the conveyor belt, when you're getting your wallet out, a TSA agent plucks a $50 bill out and says, thank you, and off you go. That's kind of what probate is, okay? So we'd like to avoid that, and that's where having the revocable family trust comes into play. It is a private document, bypasses probate, and you don't have to worry about the bureaucracy, government interfering with things. The way you would envision your assets being distributed to whoever you want them to go to, that's kind of what happens, okay? You don't need all this additional stuff. And you can amend, change, terminate that document while you are still alive. Now, some of the disadvantages, I don't even know if this is a disadvantage, it just comes with the territory. People think that when I put my assets into a family trust, those assets are protected from lawsuits and creditors. No, those are still your assets. Okay? The tax ID with that family trust is your social security number. It's still your assets. Your goal is just to avoid probate. That's why you do it, okay? It is a little bit more complex document to create, so you could do your research and you could create a family trust. It's just a little more difficult than a will. And the other issue is, just like the will, you can't list your loved one by name as a beneficiary. Because if you do, it'll get them kicked off their benefits or make them ineligible, and those assets could be going to the state for payback. So, because we still have that problem, that's where the third important document comes in. And that is a special needs trust, okay? So a special needs trust, the idea of it is that it is a document separate from your family trust. It is separate from your will. It's its own legal document, okay? And you can leave whatever you want to that trust for the benefit of your loved one. It could have $1 million, it could have $1 billion, and your loved one would still be eligible for all their benefits, okay? So they can maintain their eligibility. Assets in this trust are protected from lawsuits or creditors against the individual because it is an irrevocable trust. It is a type of irrevocable trust. Now, while most of it can't be changed, there are still some things you can change about. You can change who the successor trustees are. You can change who gets the assets if something happens to you, or if something happens to your loved one, and the home base of the trust. If you live in Illinois, you can base it in Illinois. If you move then to Florida, you can change it if Medicaid requires it. Ideally, they don't, though. There are different types of special needs trusts. So the most common, I didn't say it's the best or the preferred, but the most common is what's called a testamentary special needs trust. And this is basically where you have your family trust, and inside of it, there are some provisions that say upon my passing, a special needs trust should be created. I argue that that isn't an actual trust. It's more of an IOU, because if something happens to you, then someone's still going to have to create the trust. What happens oftentimes, why this is the case, you can technically do it, like I said, from a legal standpoint, but many estate planning attorneys, they don't specialize in disability and special needs law, and either out of a false sense of self-confidence or out of fear of missing out on the sale, if you ask them if they do special needs trust, more oftentimes not, they'll say sure. And they create your family trust with some paragraphs and provisions. And they can technically call it a trust. I have issues with it personally, but whatever. The more preferable option would be the third-party, separate, irrevocable special needs trust. I'm not going to say that whole thing all night. I'll just say third-party special needs trust. A third-party special needs trust is a trust separate from your family trust. And if it's drafted properly, Can't state that one enough. If drafted properly, it will have its own tax ID. It will have no government regulation stating what the money can or can't be used for your loved one's benefit, and it will not have any Medicaid payback. So if something happens to your loved one, those assets do not go to the state, they go to your other kids or family members or whoever, okay? It's called a third-party trust because it is funded with third-party money. So that means any and everyone can leave anything to this trust except the individual with the disability. Their assets cannot go in there. Now, if your loved one doesn't have any assets, then you don't have to worry. But if they did, they came into assets either through an inheritance because someone left them the money, or they won a legal settlement or something, they would need to put their assets into a first-party special needs trust. And a first-party special needs trust is used in those circumstances so that someone can maintain their eligibility for benefits, but it is a government-regulated trust, and the state does get the assets first upon your loved one's passing, okay? With a third-party trust, like I said, it has its own tax ID. Think of that third-party trust like a business. If you were to open up a business, you get a tax ID, you get a license, whatever, and you can open up a bank account in the name of that business. Same thing. That third-party special needs trust can hold whatever assets, and that tax ID is what's associated with it. Okay? Let's see. Pooled trust. So if you don't have anyone, you don't foresee anyone now or in the future who you entrust to look after your loved one and manage those assets appropriately, then it may be a good idea to seek out an organization who manages those assets. You know, there are nonprofits, or the ARC of whatever county or whatever state. There's trust companies. They would be the ones managing those assets for your loved one's benefit. Okay? Now, you could do that even if you have people. It's just, if you go that route, just know you are giving up control of those assets. So then you have to request permission from the organization to get distributions, and they may or may not deem it as an allowable distribution. And does anyone here work for a ARC or trust company or something like that? Good, I'm not offending anyone directly. Okay. All right, so you tell me when I tell you that, okay, that's great, you make distributions, they could deny them. Do you think that it is a conflict of interest when you have your trust set up with them, the organization is the beneficiary upon your loved one's passing? If you were going to receive assets, how generous would you be in making those distributions? Now, I know they have a fiduciary responsibility. I swear to God, if I hear that again. Fiduciary responsibility. That is like saying, I have a license to drive a motor vehicle, so therefore I never go over the speed limit. I have fiduciary responsibility. Yes, you do. Yeah, I think you get it. The last one here is what's called a Miller Qualified Income Trust. So if your income is over the limit, you can, in some states, transfer the income itself into this trust to qualify. Okay? Okay, before I jump into this, that was a ton of information. Kudos to you for no one's asleep. Holy crap. So, any questions on what I just covered? Yes? Can a grandparent do the third-party special needs trust? Yes. There is no limit to how many special needs trusts. I think my record with a family was 8, because the parents were divorced, and each grandparent was divorced, and then an uncle wanted to do something. So you can set up as many special needs trusts as you want. Each one, that person, whoever's creating it, gets to dictate who they want as the successor trustees and managing things and who gets it after. So yeah, when parents split or whatever, they might have their own agendas on who gets what, who's managing these things. So yeah, you can have as many special needs trusts as you want for the benefit of that individual. Did I answer your question? Perfect. Yes?
So kind of on
So if they have their own family trust, that's great, because the idea is they're going to retitle their assets into that trust so that you or your parents or whoever doesn't have to go through probate. That's the reason why you do that. But they can't leave anything directly to your loved one. Correct. The other route, rather than getting a third-party special needs trust, you can disinherit them and just have that share, sent to, whoever the other beneficiary is. But money does make people do crazy things and shows people's true colors. You are hoping they do the right thing. You are hoping they do the right thing. And what if they would be doing the right thing, but what if that person was in the middle of a lawsuit or a divorce proceeding? Those assets are now subjected to that thing. So then, that ex might walk away with half those funds or whatever. So earmarking it specifically for a special needs trust is, generally speaking, the best route. Plus, I gotta watch my legal suggestions here. So if you we focus so much on your loved one who's, one side of the generational timeline. We oftentimes forget that on the other side, what if mom, dad, you, grandma, grandpa, whoever it is, needs health care in the future? And I'm talking group homes, assisted homes, nursing care, in-home care. We're all getting older. Father time's undefeated last I checked. So the chances of needing that in the future is going to increase. Well, sometimes I'll have an elderly individual who will scoff at it and say, I have Medicare. I'm covered. No, you are not. Medicare, which is your federal health insurance that you usually get at 65, that does not pay for group homes, in-home care, assisted living. I don't know how many of you have experience with family members in group homes, in-home care, but that is expensive. It can be anywhere between $3,000 and $5,000 a month, $10,000 a month. So if you've ever heard of someone having to spend down their assets to qualify for health care, this is what we're talking about. So then at that point, grandma, grandpa, whoever it is, they got to qualify for Medicaid the same way as your loved one does, because Medicaid is what pays for group homes. Wouldn't it be nice if ahead of time they may transfer some of their assets into that special needs trust and out of their name so that those assets wouldn't count against them? That's all I'll say on that one. Question over here? Do you have a question? No? I saw a hand over here somewhere. Okay, perfect. Okay, any other questions as it relates to the trust? Perfect, okay. Guardianship. So most of you, minor children, mama bears, please do not claw my eyes out when I tell you this, but when your child turns 18, you no longer have the right to make decisions for them. They're an adult. There's nothing in the Constitution that provides an exemption for someone who happens to have a disability or special need. Okay? If you need to continue having access to medical records, making medical decisions, protecting them from financial exploitation, you need to petition your local county court for guardianship over your disabled adult. Okay? Each and every state, each and every county has their own respective rules. Okay? But generally speaking, what you do is you fill out some paperwork, file it with the court, and then a couple weeks later, you will have a hearing before a judge, and the judge will decide whether or not to grant the guardianship. Okay? Now, some places allow you to file early, like 17 years and 9 months or so, a couple months prior to them turning 18. Most don't, though, because unfortunately, is anyone here a court clerk? Okay, I'm not going to offend anyone directly. Okay, so it changed because these minions decide that when they get this paperwork and they see that the person at that moment in time is a minor, we're doing guardianship for a minor, which expires when they turn 18. So it was just a lot of messy stuff. They didn't have the ability to think for themselves. So oftentimes they just said, you know what, screw this. At 18, that's when you can file. okay? So guardianship can get has a little bit of a bad stigma to it. There's the Britney Spears conservatorship. There's guardian abuse. It happens. It does, okay? That Netflix movie, I Care a Lot. Anyone see that one? It's got that Gone Girl chick, that crazy, yeah. Anyways, for those of you who didn't watch it, it's basically this lady who becomes a guardian over these elderly individuals and robs them blind of their stuff. It's a great ending for those of you who saw it. But yeah, there are people that abuse it, okay? That does happen. I am not here to tell you that guardianship is good or bad. Everyone has their own unique circumstances, and guardianship may or may not be appropriate for you. So let's try to see if it will be. Some of you, it's going to be closer than others. But if your loved one is walking in the mall, I'll get to you. I can see the hand. If your loved one's walking, strolling through the mall, all by themselves, and they come across a cell phone booth, and the cell phone rep comes up to them and says, hey, I got this brand new shiny iPhone 5000, or whatever at this point. It can be yours, no money down. All you have to do is sign this piece of paper right here. You know your loved one better than anyone else. You tell me. What's the likelihood that they would, A, understand what they're doing, understand what they're signing, and B, sign it. Sign this little piece of paper to get that fun, fancy new phone. If you think that your loved one would not understand those documents, or that they would likely do that, guardianship might be the route for you. Because with guardianship, if they did do that, that contract is void because they are not able to sign legal contracts. Okay? Question back here.
Do you have to reapply for guardianship every time you move states or county?
Good question. If you get guardianship and then you move to a different state or even a county, as you said, yes, you do have to petition the court for the county that you now reside in. Oftentimes there's some reciprocity where you can provide the paperwork from the guardianship you currently have in one state and they can transition it, but you still have to go through that formal process. Some states, you have to do it even if you move to a different county in the same state. I think there's only 1 or 2 states that do that. Otherwise, it's states. Okay? Question, thought there was another hand. Any question? Yes? You can have 2. You can have co-guardians. Yes. Part of the process is you have to notify certain family members of the proceedings. You're not asking for permission. You're just kind of asking for the blessing, I guess. But you're just letting them know that, yep, there's a hearing this date and this time. You're welcome to show and fight it or whatever if you want. Now, oftentimes people have the impression that I need to retain an attorney, I need to retain legal services to do this. Unless someone's going to be fighting you, you don't need to. If you don't want to deal with the paperwork and you have the ability to do so, yeah, you can hire legal services to do that for you. We do it all the time for people. But I just want you to know it's not something that you need an attorney. You can go the DIY route and file as a self-represented litigant. Okay? Yeah?
Sorry, did you just say that you don't need permission to put somebody down as a guardian? Or did I mishear you?
When you...
I want my brother on it, and I don't even have to talk to him, and I just put him down, and I'm like, good luck, bro.
Not that. You could put that on your will. On your will, you can list who you want as the successor guardians if something happens to you. As far as going through the guardianship part, whoever's going to be the guardian, they're going to kind of have to show up for court and sign paperwork saying that. No, you can't sign someone else as the guardian. No, not that. Yeah. As far as the notification part, it's just that part of the protocol is that you have to notify certain family members. Any siblings, I think, older than 14, grandparents, parents, or children, grandchildren, if it's for someone that's a little bit on the older side. So, yeah, you just have to notify them. You don't need permission from them to go ahead with the guardianship.
Do they have to be of a certain age to put them down as a guardian? Is that what you just...
In your will, you could list someone who at that time is a minor, because we're hoping nothing happens to you anytime soon. So they're going to be in their 20s, 30s, 40s. But if something did happen to you, Whoever in that moment, they have to be 18. Got to be 18 to be able to be the guardian. Correct. Any other questions on that? Okay, yes. Some states have it where you have to renew every year or every 3 years. Other states, it's kind of just an indefinite thing, and you just have to file these annual guardian reports. Texas, I think, every year you have to get a new one. I think, Washington or somewhere, it's every 3 years you have to redo it or whatever. But yeah, each and every state, each and every county has its own rules with it. Now, the alternative to guardianship is medical and financial power of attorney. These are legal documents that actually each and every one of us should have. This is giving someone the ability to speak on your behalf over legal matters or financial or medical matters that you stated your wishes on. They're simply your voice box. They're the person that's able to speak on your behalf if you're unable to speak for yourself. Okay? Now, in order for your loved one to be able to do that, your loved one first has to understand the gist of that document. Okay. So, if they can't jump through that hoop, can't do it, because they are the ones that are signing that document. They can't sign something they don't understand. Plus, medical and financial power of attorney are flimsy at best. They don't hold up in court, and some states, some agencies and organizations will simply choose not to acknowledge them because they could say, you know what, I don't know if he or she was in their right frame of mind when they signed this. I don't know if they can sign it. I'm not going to acknowledge that. And sometimes they do it out of fear of violating that person's civil liberties and getting sued. So sometimes people will be simply asked, are you the guardian or are you not? To be able to ask or discuss medical decisions and questions and things like that. And I've had some people where they're like, I'm the power of attorney. Yeah, are you the guardian or are you not? I'm the power of attorney. Again, are you the guardian or are you not? Guardianship's more ironclad than power of attorney. Okay? And I think what oftentimes gets lost in the guardianship and the negative stigma here isn't our underlying goal to one day have guardianship removed? Because that will have meant that your loved one has grown and developed so much that's no longer needed. Like, that's our goal. And I think we oftentimes forget about that part. You know, subconsciously we get caught up in, oh, my loved one, they can't do this, they can't do that, they need guardianship. The way it should be viewed is that my loved one happens to lag behind their peers, and guardianship is needed to help protect them and put together an environment that, you know, they can safely grow and develop in without being exploited. Okay? That's the underlying goal. Obviously, we're realistic, and for some people, that guardianship's always going to be there. Okay? But that's oftentimes what gets lost in the whole thing. And as far as the negative connotation with the guardianship, how about this? Pardon my French, but don't be an asshole to your kid. How about that? Like, treat them with respect. Don't abuse them and their finances and crap. Yeah, if you do that, there's no issue. Okay? Can your loved one get married if you have guardianship? The answer is yes. Just like a 16 or 17-year-old, got to have mom, dad sign off. Same thing, got to have the guardian sign off. Can my loved one retain their right to vote? Yes. You can request it during the guardianship hearing. It can be granted. Can my loved one drive? Yes. Anyone here Illinois? Illinois? Anyone? No? Okay. Illinois, full guardianship, you can't. Limited, you can. Each and every state has its own rules and stuff, but yeah, your loved one can retain their ability to drive. Just like a 16 or 17-year-old, got to have mom, dad sign off, got to have the guardian sign off. Okay? So it's not like you're stopping them from all these things. And they actually have the right. Each and every county is different. But oftentimes during this filing process, your loved one will actually get appointed an attorney from a nonprofit legal aid center in your respective county. So they do have someone, representing them because, we are talking about taking away some civil liberties there. So they have rights as well. So they do get that representation and are able to, fight and contest things if, there is, allegations of abuse or whatever, okay? Let's see, what else with guardianship? Any other questions as it relates to guardianship? And you're all still awake, why? I don't know. Good for you though, okay. Let's see here. Okay, so quick review of that. No plan, government's gonna be making decisions. First document they have in place, the last will and testament. Second is the revocable family trust. Third is the special needs trust, and just depending on your situation, might be 2 or more special needs trusts. Medical and financial power of attorney for yourself, and then for your loved one, either that or guardianship. Let's see. Oh, by the way, whoever the guardian is, that does not mean that they automatically get access to assets in the trust. Unfortunately, I have had families where maybe the grandparents are looking after the grandchild because the parents are degenerates and junkies. And then they get word that mom, dad, grandma, grandpa, whoever, is leaving assets to their child. And all of a sudden, they become more present in their life. And maybe through manipulative tactics, become their guardian. And maybe they reach out to one of our attorneys and say, well, we're the guardian now, so just hand over those assets and we'll take care of it from here. And we politely just tell them to kick rocks because they were excluded in that trust. And that's it. Game over. You can be a guardian without being a trustee. So if someone does look at them as a paycheck, even if they get to that point, just know that if you exclude them in the special needs trust, nope, they don't get those assets, okay? Because the guardian is simply responsible for making sure that they have a roof over their head, food on the table, getting the doctors. They don't need to get their hands on any of these assets. And that's whoever your trustees are, okay? All right, government benefits. There are cash programs and there are medical programs. And we're gonna go through those. So in a nutshell, we oftentimes use these phrases incorrectly. We say Social Security disability when actually we mean SSI or vice versa. Supplemental Security Income, or SSI, is a monthly cash program administered by Social Security for individuals who have a disability prior to the age of 22 and have low income and assets. Just by the raise of hands, how many of you have SSI for your loved one? Anyone? Okay, a couple people. Okay. So you can get SSI for your loved one when they are a minor, but they will look at the parent's income and assets as well as the disabled adult or disabled child. Okay. So if you have tried to apply for your minor child and got rejected, for what it's worth, you're probably in the majority of people because you have to show basically nothing to qualify for them as a kid, okay? But SSI, I think the monthly amount right now, the max is $943 a month. And on one hand, the government thinks your loved one can live off of $943 a month, and it's kind of ridiculous. On the other hand, if your loved one lives to the age of 80, that's about $1 million in cash benefits. So it's not nothing. It can definitely help them as you're planning for them now and in the future. There is Social Security Disability Insurance, or SSDI. When you have worked and paid into Social Security and then become hurt and unable to work, you would file for Social Security Disability. Okay? SSI is for someone who really hasn't worked and has a disability prior to the age of 22. Okay? SSDI is for someone who's worked and paid into Social Security. Disabled adult child benefits. So if your loved one is on SSI and then the parent retires and starts collecting Social Security themselves, their child could be transitioned to the DAC benefits, which is roughly 50% of what the parent is getting in Social Security. And oftentimes that can be a bump up. We'll go over that in more detail here in a second. And then there's retirement survivor benefits. So yeah, when you reach 62, 65, whatever, you start claiming Social Security. That's your retirement benefits. And the survivor benefits, if you were to pass away, your loved one gets a little bump on their monthly amount. Let's see. So SSI, like I said, pays monthly benefits to disabled adults and children who have limited income and resources to meet their basic needs. There's SSI for children, SSI for adults. Some states do offer a little additional amount, between $50 and $200. There are rules though, financial and medical rules. We talked a little bit about the financial ones. $2,000 of assets and roughly $1,500 in income. It varies a little bit for minors compared to adults, but yeah. And then the medical eligibility, if they are a minor, Social Security is only going to look at, do they have the diagnosis, do they have that disability? But as an adult, they're going to look at, okay, that's great that they have that disability. Are they able to hold a job that could provide them a bare minimum standard of living? And I mean, you could have someone who's very high functioning autistic, okay? If they're able to hold a job and support themselves, then they possibly couldn't qualify, okay? Go over that here more in a minute. Karen, how are we doing on time? Okay, so SSI for children, a person who's not married, not head of their household, under the age of 18, or under age 22 and is a student regularly attending school. Ideally, once they're 18, you're applying for SSI as an adult. There's more benefits to that. Let's see, based upon the household income, like I mentioned. So if you're looking at SSI for your minor child, then here's a little bit of a graph that talks about how many parents are in the household and how many kids are there, how much income is the max that you can have in those situations. And you get a $2,000 income exemption, you gotta be below $2,000 of assets to qualify for it, okay? Let's see here. Like I said, just meets the definition of disability. And luckily for you guys, as it'll show somewhere on the slides, that in 2022, Moat Wilson became a disability that was put on what's called the Compassionate Allowances List. Yes, it's kind of your fast pass to getting approved when it comes to the medical eligibility. So you kind of zip right through, okay? That's one bright spot for it. Let's see, child SSI recipients can expect to receive redeterminations, usually once every 3 years. You have to continue to show that, yes, this person still has this disability. It's a little annoying, but it is what it is. And if your loved one has SSI as a minor, you actually are already in the system. You have a leg up from the competition. So upon them about to turn 18, it would be a great idea to go into Social Security a couple months prior and sit down with someone and see about transitioning them from SSI as a minor to SSI as an adult. That's going to be the most efficient route to go, rather than filling out a brand new application. Okay? Let's see here. And then for adults, most people have to wait for SSI until their child is an adult because, again, the parent's income and assets come into play. But when they turn 18, they're an adult, and Social Security only looks at the child's income and assets. Most people don't have much in assets when they're 18. So as long as that's the case, and you clear things out, then you're good on that part. Let's see here. Yeah, parents' income and assets not countable. Let's see, substantial gainful activity. Basically, like I said before, can this person hold a job that could provide them a bare minimum standard of living? Okay? Let's see, what else? There are certain types of income that do count and other ones that do not count for eligibility for a minor. Let's see here. Everyone take their pictures if they want to. Click now, forever, hold your peace. Okay. Adults, yeah, $2,000. Non-exempt assets, so ones that will count against them, cash, bank accounts, investment accounts, exempt assets. So technically, your loved one can have a house in their name and still qualify for SSI. Same thing with having one car. They could have a Ford Pinto, or they could have a Lamborghini, and they'll still qualify for their benefits. One car. And up to $100,000 in an ABLE account. By the raise of hands, how many of you have heard of ABLE accounts? Or, yeah, the state agencies are doing a great job at getting to you. We'll go over those here in a second. They're not totally bad. Just putting things in proper context is important. Yeah, I talked about eligibility. So I think the percentage has increased to around 40%. 40% of people are getting approved for SSI the first time around. That's a plus. I think about 5-6 years ago, it was like 20%. And it's not because 60-80% of people don't qualify. That's not it at all. It's just simply a good strategy as a business for Social Security to reject a whole bunch of people, because a whole bunch of people are going to give up and quit. And everyone that does that, that's a victory in their eyes. Yes?
Okay, my kid is only a year old. We applied, got denied, and so I'm confused already. None of this, like, one of those slides said you have to make less than $1,500 a month for a household to get approved.
$1,500 as an adult. If it's a minor,
So it's like between my husband and I,
2 parents in the household, depending on the kids, like 53-ish, something like that.
so that's 2 parents in household. We have 4 people in our home. That means that's saying right there that we have to make less than $6,000 a month.
Yes.
I made less than that. Why did I get denied?
Well, what I just said as well, oftentimes it's just a good strategy to not have to pay out. So if you do get denied, appeal it. Continue to appeal. You can apply as many times you want. There is no max to how many times you can apply. I see a hand back here. Yes?
We were eligible for SSI, and I got a job, set in my stubs, and then they said you're no longer eligible. If things change later on, if I decide to stay at home again, can I reapply again? Is it easier if I've already been qualified once?
You are in the system, and if they qualified you, it means that financially they qualified you, but things change. But medically, they did as well. So as long as the medical part's still the same, yeah, you could reapply and, hey, these are my finances. It would be a good idea to, a couple months ahead of time, sit down with someone at Social Security to transition to SSI as an adult. You already have your foot in the door. Why go through the application again when you can sit down with someone and get them transitioned? That would be the better route. He's in this, well, he has to be receiving SSI in that moment because you're just trying to transition him. Yeah, correct. Yes.
So state of California offers its IHSS program for parent providers. So the state pays us. It is non-tax money.
You're beating me to the punch here. I want to properly address you, Judy. Jody. Jody.
So when your spouse's income is not consistent throughout the year, so like part of this, like summer months, he makes decent. He would beat that money amount per month, but in the off season in the winter, we're under.
They're going to ask for like annual tax type of statements, financials. So that's where you have to get crafty with your accounting and all that fun stuff. Yep, there you go. So as far as applying for SSI, you can apply online, you can apply in person, or you can call and schedule an appointment. Let's see. Again, application can be frustrating, maddening, confusing, because again, oftentimes people do qualify, but they get denied. Appeal those things. And so, what I suggest to people, oftentimes when people are going through this process, they unknowingly provide bare minimum information. They provide their current doctor and current therapist. Very bare minimum stuff. Provide any and all medical and educational records, doctors, reports, agencies, early childhood intervention, all that stuff. The way you got to think about it is that someone in some back office of the Social Security office is sitting here and denying and approving applications, like college admissions, basically. What's going to make your resume stand out from the competition? So, good idea to, well, again, hooray, Moat Wilson is on the compassionate allowance, so it shouldn't be, hey, did you provide them with the Moat Wilson stuff? Happy to have a further private consultation with you and go through. Yeah, if the finances are in check, providing the genetic reports and all that stuff for Moat Wilson, that should, again, it's on the compassionate allowance list now for the past 2 years or so, should help increase your chances in getting approved the first time around. But what was I saying? Oh, so there's a Social Security Blue Book, which is like a manual that Social Security uses to determine someone's disabilities. So aside from Moat Wilson, it can also get categorized as an intellectual disorder or developmental disorders in infants and toddlers, just so you know. But what I was getting to is put any and every bit of information you can from any letters, any data or research from doctors, therapists, previous bosses, employers, caretakers, workers, organizations, talking about how this person has this disability, and especially if they're an adult, how they are unable to work, citing the specific things as to why they can't work. Can they not count money? Are they unable to move physically? Can they not, crouch, stand long, things like that? That's going to help increase your chances of getting approved first time around. Yeah.
I'm looking at it in Georgia. I don't know if this is a state or regional.
We'll find out.
We don't qualify for SSI, but there's something called the kitty packet.
You're beating me to the punch.
It's also a pitch to get, but for people that don't qualify for SSI, that's like the next option.
Yes, and that leads me to it somewhere along the way. One sec. SSI, who's getting SSI right now? Who's getting SSI for their adult child? Anyone? Okay. Those who were raising their hands, how many of you are getting at least $900 a month? Okay, good. Oftentimes, people are getting $500, $600 a month, and they don't understand why. It's because you need to create a rent contract saying that you are charging your kid rent. Sounds stupid. I'm not going to charge my kid rent, but SSI is for food and water and for shelter. And if they don't have proof, if they don't have a rent contract, obviously you don't need half this money. So create one saying that you are charging your son, John Doe, $600 a month. It's the same amount you would charge anyone. Sign it, submit it to Social Security. That helps solve that problem. And you do have to, as awful and as cold as it sounds, you have to depict your loved one as just someone off the street almost, that they're not getting any help or support from anyone. They're responsible for all their own bills, rent, household expenses, food, because if they're getting help and support, that will reduce your amount. Yeah. If denied, like I said, you can appeal it and you can continue to apply over and over again. If you do end up getting a Social Security disability attorney to fight for you, just know if they ask for any money up front, you should probably get up and walk out, because it is illegal for a Social Security disability attorney to charge you anything up front. They're kind of like an injury settlement attorney where they get a percentage of the back pay upon winning your case. Okay? So they don't cost anything up front. They just get a percentage of the back pay that's owed to you by Social Security. SSDI, like I said, is for someone who's actually paid into Social Security and then becomes hurt. And let's see. SSDI does not have the same asset and income limits as SSI does. Let's see. Minor children can get SSDI if their parent is getting SSDI, or if your loved one is getting SSI and they're working. If they earn 6 credits before the age of 24, they actually can get transitioned to SSDI. So that way, you don't have that same income limit. Because if they're on SSI and they're working, it will reduce according to how much they're making. It will fluctuate like that, just so you know. And if they get SSDI, then they will transition to getting Medicare for the health insurance part. Go over that here in a second. So, typical family situation. The kid doesn't get SSI as a minor, parents have too much in income and assets, but at 18, they get SSI. And then somewhere down the road, mom, dad retire and start claiming Social Security, okay? And let's just say that their Social Security amount is $4,000 a month. Their disabled adult child is eligible for 50% of their parents' Social Security. It doesn't mean that it's taking anything away from their parents. It's just a calculation. So in my hypothetical, 50% of $4,000 is 2. And last I checked, $2,000 is more than $943 in SI. So they will transition to getting the disabled adult child benefit now. And that doesn't have the same income limits as SSI. And then if the parent was to pass, add 25% onto that amount, okay? And when they transition to it, they will also undergo a transition from not only getting Medicaid, but getting Medicare, which we'll go over here in a second. We'll go right into your whole waiver thing. So, oftentimes we use these words incorrectly. Medicaid. Medicaid is your state health insurance that you have to have minimal income and assets to receive. Medicare is your federal health insurance that you get when you retire at 65. Okay, Medicare is your federal health program, does not have those income and asset limits. Medicaid does. Okay? Medicaid has the traditional health services, doctors, hospitals, prescriptions, but Medicaid also has what's called a Medicaid waiver program, AKA Katie Beckett, or whatever you call it in your state, okay? It provides additional supports and services for someone who has a disability, okay? Let's see here. I think I mentioned before that Medicare does not pay for long-term care, in-home care, nursing, things like that. That is Medicaid. Medicaid is what provides paid caregiving, group homes, in-home care, all those additional supports and services, okay? But they do both provide some things like doctors, hospitals, prescriptions, things like that. And someone can eventually have both, like I said, Medicaid and Medicare. It's being dual eligible. If you like your private health insurance policy, by the way, some people worry that, okay, my kid's gonna be 25 soon, or 26, and they're gonna have to come off. No, they do not. Legislation over the past 10, 15 years has allowed a disabled adult child to stay on their parents' health insurance policy for life. Obviously, if you quit that job, then no. But if you stay with that job, you retire with that job, pass away while being employed, yeah, they can stay on it. If you're willing to pay those premiums and you like the benefits you're getting, great. And depending on the state you're in, some states offer incentive programs that will actually reimburse you your health insurance premiums to keep them on it. Because as having that private policy and Medicaid, the private policy is your primary. So states like to offer that incentive so that they don't have to pick up much more of the bill. So most states have it, some states don't. Might be worth checking out if you have a disabled adult child. Let's see, what else? When you get approved for SSI, many states will automatically just approve you for Medicaid. Some states do not. So let's see, yeah, most of them, you'll just automatically get approved. Some states you'll get approved, but you still have to apply, like Alaska, Idaho, Kansas, Nebraska, Nevada, Oregon, and Utah. And then some states decide that they're fancier than others and have their own income rules, which are very close to the federal ones, but they have their own. And you have to make sure you're meeting their thing and applying for it. Okay, Medicaid waiver. So, well, I kind of already talked about that a little bit, but Medicaid waiver. So, thank you to your point. If you get denied SSI for your minor child, you have too much income, assets, whatever, okay. You can take that denial letter along with some other documentation to Medicaid, and at the very least, get your kid on the Medicaid waiver wait list. How many of you have the waiver or are on the wait list? Or Medi-Cal? Yes, Medi-Cal. You guys are fancy over there in Cali. Yes. The Medicaid waiver provides those additional supports and services for your loved one, okay? Things like occupational therapy, speech therapy, behavior, various types of day programs, group homes for adults, paid caregiving. Sometimes you can be the paid caregiver over your minor child. A lot of states can't do it while they're a minor. They figure, yep, you're the parent, do your job. And as adults, though, you can. If you are not on the waiver wait list, you should definitely get your kid on the wait list so that they can start getting benefits as soon as possible, okay? So you're gonna want to talk to, each and every state's different, has their own agency that oversees those things. So you wanna talk to them and get them on the wait list. Yes?
I was just gonna say that in our situation, we got approved for SSI, but it was we were approved for $0. But even being approved for $0 allowed us to get respiratory from Medicaid.
Yep. So if you haven't, I would strongly encourage you to get your kids on the wait list as soon as possible to start receiving these different types of services, because the funds are there for the states. Every state's a little different, but I mean, the state does have to balance their budget, believe it or not. So when they do approve someone, they do have to approve a certain amount. That's the maximum amount that can be used on that person. And for kids, oftentimes it's between like 20 and 50,000, and for adults it can be 50 to 250,000. Now, they're not going to advertise it that way to you. You have to be prepared with a plan of throwing out everything that you need, okay? If you're looking for them to roll the red carpet out and asking them, well, what can you offer me? No. What do you need? You tell me. So be proactive, putting together a list of any and all the things you could possibly think of to get. You can get medical equipment, you can get wheelchair ramps, all sorts of stuff through the Medicaid waiver. Yeah?
We ended up hiring somebody to work through this process, and they're very good about helping you get it all together so you can maximize your outcome.
There are services that can do those things. You can go the DIY route, and there are services that are able to kind of help you out with those things as well. Let's see, yeah, there are different services that focus on people who have more of the intellectual cognitive delays, and others that focus more on the physical disabilities and things like that. But yeah, that's a lot of supports and services that you could be receiving through it. I have one family in California, and through their regional center, they're getting like a $70,000 tuition to an art program paid for by it. You know, just crazy things like that. So the states have money. They might say they don't. They got it. Let's see. Like I said, Medicaid waiver, the kids, it's the Katie Beckett. Adults, just the adult waiver, and different types of services. Some states have wait lists, others do not. And depending on the severity, you could go further up in the wait list. Get them on as soon as possible. Let's see. Yeah, apply as early as possible. The sooner you apply. Don't stop advocating for services for your loved one. Be in constant communication with your case manager. If you don't like your case manager, because bless their hearts, oftentimes they are paid very minimum and they are understaffed, where they have 200, 300 families apiece and they can't see everyone, and oftentimes it makes people quit. And so a new person comes in, doesn't know anything. So if you get someone who's just a total piece of work, or they are incompetent beyond belief and you're teaching them more than they're teaching you, don't be afraid to request a different case manager. Because a big key to these services, it's the parent advocating and the case manager knowing what they're doing and advocating for you, and not being some gatekeeper thinking it's their money and being a stickler and everything. That's what makes it happen. Let's see here. Like I said, as far as the transition of benefits, get into the DAC benefits. Even if or when your loved one goes from Medicaid to Medicare, they can still keep the Medicaid waiver. They can still keep those services. Just keep in mind, those income and asset limits will still apply. Even if you don't have SSI still, you still got to worry about the whole Medicaid part, okay? Microboards, geez, if you don't like the agency you're working with, you could create your own agency. Mind blown. Okay, we're not going over that. That's way too complicated, but you can take more control of your life. And then there's budget and financial planning, okay? So it can be tough balancing all your goals both now and the future. Any other kids, any other goals you have, I get it. And it is important, it's still important though, to jot down on paper, actually crunch the numbers and figure out if your goal is for your loved one to continue. I get it, Karen, I'm getting there, okay? If you want your loved one to maintain their same lifestyle, what's that going to cost? I'm sure that you'd be surprised when you actually crunch the numbers how much it costs. What's that going to take? What are going to be your source of income? SSI, disabled adult child benefits? What's it going to be? Okay? So it's important to jot those things down. How can you save for those things? Investment accounts, savings accounts, or maybe you even take part of your SSI and put it towards a life insurance policy. So if you're planning on having your loved one live with you, and the concern is after something happens to me, then what? If that's your concern, well, life insurance policy, there's a death benefit to help carry them the rest of the way. So that's a potential strategy. ABLE accounts. ABLE accounts were created about 10 years ago by the government, and you can put money into it, more than $2,000, and your child can maintain their eligibility for benefits. Sounds great, and it is. It has a benefit. When you have a properly drafted special needs trust, it takes away a lot of the shine that's on ABLE accounts, because ABLE accounts are state regulated, so the money in it can only be used for certain expenses. You can't list it as a beneficiary, and upon your loved one's passing, the money in an ABLE account will first go to the state for payback, whereas a special needs trust is not. But it can serve a purpose. I know we're cutting close on time. If you have that feedback form and you do need to go, we'll wrap up here in 2 seconds, but if you do have it, please fill it out and then just either leave it on the table or put it on one of these chairs up here. But there is a website for the ABLE accounts. So if someone doesn't have a special needs trust and grandma, grandpa, whoever's giving cash, rather than stuffing it under the mattress, you could put it in the ABLE account and they can maintain their eligibility for their benefits. So the final part is the lifestyle and transition planning. So let's just say that you've done all the legal planning. Great. And you have put all the government benefits in place. Fantastic. And hell, you've even done the budget and financial planning. As taboo as finances are, you did it. Good for you. I'm willing to bet that for many of you, your child couldn't care less about any of that. What they care about is at 1:05 p.m. every day, they're watching SpongeBob in their orange shirt, eating peanut butter and jelly sandwiches, white bread, crust cut off. That's what's important to them. If it's important to them, it should be important to us. So we create what's called a letter of intent. And it's kind of like a living, breathing caregiver guide into who your loved one is. What are their likes, dislikes, behaviors, tendencies, anything that any future caregiver would need to know. You can write these things down, sure. Another way you could do it, oftentimes what we do with clients, is we will create a private YouTube channel. Totally private, and you can put audio recordings, video recordings of how to operate medical equipment or whatever it is. And you can add to it or whatever. And then the only people that are going to have that username and password are your future caregivers. And that's going to help them better understand your loved one, make it as smooth a transition as possible if and when that time comes. Okay? So next steps here are filling out that feedback form. If you have the government benefits, the legal planning, the budget, financial planning, and the lifestyle transition planning in place, that is a way of covering all the angles to make sure that your loved one is maximizing their opportunities now, as well as in the future, and continuing to grow and develop and making sure that your wishes are indicated. So I want to thank the Moat Wilson Syndrome Foundation for having me. They've been fantastic, and this whole thing has been just wonderful here. And if you want, you're welcome to bring your feedback form up to me here. I'll kind of be here, or you can leave it at the table, and I'll just come around and pick it up. And I want to thank you all for attending, and hope you enjoy the rest of your day.